Good morning, good afternoon, or good evening, wherever you may be, and thank you for taking the time to be with us today. My name is Akash Chaube. I'm a partner in the corporate and private equity practice group at Khaitan & Company. Your tax in India are two words that are seldom liked when used in the same sentence. You will hardly find anyone across the globe who has not heard of the India-Mauritius tax treaty or the Vodafone case in context of doing business in India. Now, amid the COVID-19 pandemic, the news of an unfavorable ruling from the Authority of Advanced Ruling, popularly also called as AAR, to Tiger Global, a leading financial investor and one of the sellers in the mega transaction involving acquisition of Flipkart by Walmart, it had the headlines. On a first read, it appeared to me as a corporate practitioner that deal making in India will go back a decade with the recent development. But as I engage with my tax colleagues, and some of them are on the call today, I learned about some nuances that are important for us to understand and plan ourselves. In this context, I would like you to extend a very warm welcome to our audience in India and across the world through this webinar, Advanced Ruling in the Tiger Global's Flipkart deal, Perspectives and Road Ahead. Before we begin, some format and housekeeping rules for y'all. The format today is of a Q&A session, which will be followed by a Q&A with your questions, and that is an opportunity for you to raise the questions that are important to be discussed and hear the views of our experts. You can submit your questions online at any time during the webinar and towards the end of the session. You can simply use the facility in the webinar portal. We will endeavor to answer as many questions as we can, and just in case, because of want of time, we are unable to do it, we will send an email response to you. Copy of the webinar as well as the recording will be made available to you after the webinar. Maybe I can take you through the broad agenda so that you can plan yourselves in the next 45 to 60 minutes. We will try to cover 4 broad topics. The first topic is, of course, why we are here, the analysis of the Tiger Global ruling and its implications on similar situations. The second is again very important to discuss the overall tax climate in India, especially from offshore investment structures. Third, and very important, is to see what the tax department is thinking through. Looking at through their lens is another topic that we would try to cover today. And lastly, we have a esteemed panel here, so we won't let them go without getting some best practices on tax negotiation and structuring. Now this conversation can't be complete till we hear both investors' perspective as well as global perspective from people who have observed this landscape over 2 to 3 decades. And we are very fortunate and privileged to have a remarkable panel for the discussions today. So I would love to introduce the panelists to you. If I can request to change the slide, that's great, thank you. Our first panelist is Rashmi Gupte, CFO and General Counsel at Lightbox. Hi Rashmi, thank you for taking the time out to spend with us. Now Rashmi has donned several hats, having spent initial years at a number of companies, including ClearTrip, followed by a number of years at Sherpalo India, and now for about 6 or 7 years in her present role, including as CFO and General Counsel at Lightbox. Now, as you know, Lightbox is a sort of a marquee investor, having deployed billions of dollars in across 20 companies across sectors. More importantly, they have exited also a number of situations, and that, I think, the India perspective and the exit will come very handy in our discussions today. Our next panelist is James Anderson, who is a tax partner. He's based out of the London office. He's been in the profession, in the legal practice since the 90s, and leads Cadden Up's European tax practice as well. Again, very interesting for you to know that the team that James leads is recognized as best international tax team by a number of awards, including Transatlantic Legal Awards in 2018 and Tolley's Accession Awards in 2019. It won't be unfair to mention that James has covered taxes, checks on pretty much all kinds of corporate capital markets and investment fund transactions, especially also advising a number of governments on international financial centers and emerging tax and corporate laws. I'm also joined by my tax partners, Bijal Ajinkya and Ritu Shaktawat. Both are tax partners in Khaitan & Company's tax practice. Bijal, interestingly, dons 2 more hats. She's also part of firm's funds practice and also heads private client practice. Prior to joining the Khaitan & Co in 2013, she was head of the tax and funds practice at a boutique firm, Nishit Desai Associates, for 13 years. And again, I would like to mention, very contextual to today's discussion, is that she was leading the entire debate and the litigation on Azadi Bachao Andolan case before the Supreme Court, which in a way sort of set out the landscape for India-Mauritius tax treaty. Also for Bijal, she advises a number of tax insurance companies on tax policies while mitigating the M&A transactions in India. Both Bijal and Ritu have been advising private equity firms and strategic players on inbound and outbound investments, and of course, supplemental transaction tax advisory. So thank you all of us, James, Rashmi, Ritu, Bijal, all of you on today's panel. And before we get started, and to make sure that the god of technology is with us today and we don't have any hiccups, we also are using a sort of a short, interesting live audience poll. So if I can request to see our first test poll and first question, in which everyone in the audience can try to respond. May I request the first test poll, please? You will see the poll shortly, and you can use your mouse to use who do you expect to be the next White House resident. Would it be Donald Trump or Joe Biden? Let's see if we can beat our predictions. And while I would love to vote, I am told that organizers and panelists can't vote, so unfortunately, none of the panelists here can vote. We'll give it a few seconds and then, the 20-odd seconds, and then we'll perhaps look at the results. Great. So team, can we see the results if those are available? Wow. So this is, again, very narrow lead. And I think it's quite going the Economist survey route that it seems Joe Biden seems to be trumping Donald Trump here. Can we also do a quick second test poll to make sure everything is in place? And while it comes, I can read out the question to you. What do you expect India's GDP growth forecast for this financial year? You can think of your answers and then take about 30 seconds to respond. So 1.50 or negative growth. Again, important because all of people on this webinar are commercial people. Let's see what general sense in where our economy is headed. Maybe another 5 to 10 seconds and then I'll request the team to show the results. I'm an optimist, so I hope it doesn't go. Not preempting responses from the participants. If the response are ready, we can see. So great. So my optimism doesn't reflect in the way I think the audience is looking at it. Quite a negative growth. I think pretty much 70% looking at sub 1%. Anyway, we can, ladies and gents, and without further ado, let's get chatting on our topic today. So my first question is, is the recent advanced ruling in the Tiger Global, in the widely publicized deal, has got everyone's attention. And before we deep dive into the session, may I request Bijal and Ritu if you can run past our audience through the ruling. It is, I know it's complicated, not first read, so if you can spend few minutes taking us through and the audience, that will be very helpful. Ritu, Bijal.
Sure. Thank you, Akash. So before we get into the specifics of the ruling, it's important to understand a few basic Indian tax aspects which are involved in this kind of litigation and what led to this ruling and litigation. So firstly, Indian tax law has a very strict withholding tax regime. What that means in a cross-border M&A context is that a buyer buying Indian assets directly or indirectly has to ensure that it withholds taxes which are payable by the seller before making remittance of sale consideration to the seller. So the tax deduction happens at the first point itself. Now, the discussion becomes important when sellers say that while, of course, the transaction is taxable under domestic law, but under the applicable tax treaty between seller's jurisdiction and India has an exemption, and sellers try and claim that exemption and tell the buyers that rely on this exemption and you're not required to withhold any taxes. But given the strict withholding tax regime, wherein if buyer is seen as a defaulter, then applicable taxes can be recovered from the buyer himself, along with interest, penalty, long-drawn litigation, etc. And the case in point is here, of course, the Vodafone case, where sellers' tax are still being, recovered, and there's litigation going on against Vodafone for recovery of taxes and humongous interest and penalty costs. So this is why buyers generally do not readily accept sellers' treaty eligibility claims, and they generally seek specific protection to protect them against the risk in case the treaty eligibility of the seller is questioned. They would not want to take that risk on. So this is where the modes of protection becomes relevant. So under Indian law, there are two modes which the parties could explore. One is where seller can approach the tax officer and get a nil withholding tax certificate from the tax authorities. So this is done after presenting all the facts, and if the tax authorities are convinced, then they will issue a nil withholding tax certificate to the sellers, and buyers can rely on that certificate and not do any withholding. The other option which can be explored is the option to approach the authority for advance rulings. It's a quasi-judicial body under Indian law which can decide on taxability of non-residents, and the rulings pronounced by authority are binding on the taxpayer making an application and tax authorities. So this sort of gives an absolute clarity and comfort to the buyer that relying on the decision of the authority, it can decide its withholding tax obligation. Now, of course, the choice is not too simple. There are various factors at play, whether to go for one option or the other. And then there is a second bucket of protection, which is the whole contractual, protection, where we look at indemnity package negotiations, parent guarantees, escrow mechanisms, or even tax insurance, which is gaining popularity in the Indian M&A tax context. So, of course, the best option is decided after evaluating a lot of factors. Now, let's look at what happened in the Tiger Global ruling. So if we can go to the next slide. So this slide depicts the ownership structure and the transaction. So this is where three Tiger Global Mauritian entities were involved. They were selling their shares in Flipkart Singapore as part of the larger deal where Walmart acquired majority stake in Flipkart. Flipkart Singapore held investments in Indian entities, and that is why Flipkart derived substantial value from India. What this meant was that under domestic law, the sale by Mauritian entities of shares of Flipkart Singapore was taxable in India because of the amendment which was introduced in 2012, as per which transfer of shares of a foreign company is taxable in India if the target foreign entity, like Flipkart Private Limited Singapore in this case, derives substantial value from India. This is where the Tiger entities took the position that since they are Mauritian residents, under the India-Mauritius tax treaty, this exit should be exempt from Indian taxes and buyers should not be required to withhold any tax. And presumably, to convince the buyer, Tiger entities first approached the tax authorities to get a nil withholding tax certificate. But after evaluating all the facts, tax authorities refused to give a nil withholding tax certificate. They basically concluded that decision making of the Tiger Mauritius entities was not in Mauritius, was not with them. The decision making was actually exercised by the US entities. So on this basis, they rejected the nil withholding tax application and rather issued a withholding tax certificate requiring buyers to withhold tax at 6% and 8% in case of these entities. After that, the Tiger entities approached the authority for advance rulings to get a ruling on their withholding tax position. And authority sensed tax avoidance. And on that basis, the authority for advance rulings refused to give a ruling on the issue. Now, under law, authority is empowered, rather not empowered, authority has to reject an application if the issue which is involved in the application relates to a transaction which is designed prima facie for tax avoidance. So this is important. It doesn't have to conclude that there was tax avoidance. Just a prima facie tax avoidance could lead the authority to reject an application, and that is what happened in Tiger Global's ruling. And the factors which the authority, along with tax officers, what they looked at was the ownership and the control over the Tiger entities. They looked through the structure and saw that the ultimate ownership rests with the Tiger US entities and US persons. The board of directors, when the tax officers looked deeper into the board minutes, how the board meetings were conducted right from the acquisition until disposal of shares, they figured that in these meetings, US resident directors participated and Mauritian directors were merely acting as on the directions of the US directors. Basically, they were not independently exercising decision making. So brain and head was considered to be outside Mauritius, not in Mauritius. Interestingly, in this ruling, another factor was picked up by the tax authorities and the authority for advance rulings, which couldn't be justified or explained by the Tiger entities, and this was on exercise of financial control. What happened in this case was that the Mauritian entity's bank account was operated by a US person who was the ultimate founder of the group. He was the sole director of the ultimate parent company of the group, and he also had similar, signing authority with respect to bank accounts of the other parent entities of the group. So this US individual had the authority to sign checks for transactions exceeding a limit of 250,000 US dollars. So that kind of led the tax authorities and the AR to believe that the Mauritian entities were not exercising financial control over their own affairs, but it's the US person who had the authority. Looking at all these factors, the AR concluded that there is prima facie tax avoidance involved since the control and management was not in Mauritius, and therefore it refused to pronounce a ruling. And another important factor which emerges from this ruling is that while the authority rejected to pronounce a ruling, it also said that even if we look into the merits of the claim of the seller, the India-Mauritius tax treaty only gives exemption for direct transfer of shares of Indian companies and not indirect transfer of shares of Indian companies, which was the case here. So that is what the ruling, the AR held. It says that even on merits, the taxpayer had no case to claim treaty benefit. So it's kind of, a hybrid between AR rejected the application, at the same time it ruled on merits. And this is where I'll pause and I'll like Vijay to, just quickly react to some of the points, for example, the financial control and the whole indirect transfer of it.
Sure. Thank you, Ritu. So I guess the two important considerations which the advanced ruling authority has looked at while rejecting the admission of the application is one, the concept of financial control, and the second, I would say the financial control. They, somewhere in India, it's always confused with the beneficial ownership concept. And of course, the second important, criteria essentially being indirect transfer, which essentially goes on to what the object and purpose of the treaty was. Now, in any particular investment vehicle, it is but natural for the controlling shareholder or the parent to actually want to exercise control not only with respect to investment and divestment decision making, but also with respect to financial control. When we really look at this particular ruling as well as the others, which have been negative rulings with respect to Mauritius, all those cases have been situations wherein a particular individual, without having any specific formalized position, was essentially controlling that particular entity. So I think what, a good takeaway from this particular ruling is the fact that in a situation where control is essentially required, it should be a formalized appointment, either by way of having board control or by having some level of a shareholder control. You can always have certain decisions, which are strategic to the company, only being taken by the exercise of a shareholder vote. And if at all the intention was for the controlling shareholder to have certain powers, and if at all it was a situation where they do not want really board representation, you can look at a concept of a shareholder control. So that would be my first reflection. The second essentially really being on the entire concept of what is beneficial ownership. Under tax law and under corporate law, especially with respect to corporate compliances, is diametrically opposite. What the corporate law compliance requirement essentially deems to do is to essentially look through all the corporate structures to essentially identify the individual behind this mirage of entities. That's not really the concept of beneficial ownership under the Indian tax law. When we're looking at the concept of beneficial ownership, it essentially refers to concepts such as agency relationships, nominee arrangements, etc., wherein the person who is in receipt of the funds is not the true and real owner. Now, when you're looking at it from the concept of shareholders really receiving a dividend, right? Receipt of a dividend is absolutely at the discretion of the board as to whether they really want to announce a declaration of dividend. And just because you have, you would obviously have shareholders behind a corporate structure, you cannot say from a tax perspective that they would be considered as beneficial owners. So I think that's the little difference and the confusion which, if I may say, the tax authorities have very successfully tried to bring out in this particular ruling. But this is a point which needs to be very clearly dissected, and I'm sure in the next, rulings to come, this will be a concept which will actually find some finality. Looking at the concept of indirect transfer, and of course, when we look at the entire object and the preamble of the India-Mauritius Tax Treaty, the preamble very clearly states that the object and purpose is to really foster mutual trade and investment between the two countries, which is here, in this case, it would be India and Mauritius. Now, when we look at the manner in which Article 13, which grants the capital gains tax exemption, is worded, it seems to appear that indirect transfers by Mauritius companies of Indian citus assets would also be tax exempt. Now, I think here the tax authorities are really trying to blow hot and cold at the same time. At the one end, they are trying to say that an indirect transfer is a deemed Indian asset, and because the substantial value of that particular Singapore vehicle is in India because of the value of that particular, the investments having flown into the country. On the other hand, you're trying to say that the object and purpose of the India-Mauritius Treaty was only to allow for direct investment. I would say here the commonly understood professional view is that any tax treaty also allows for an indirect transfer benefit, and to that extent, this particular dicta of the of the authority, I would feel is flawed. So I would say these are the main contours of this particular ruling. One is the concept of financial control, merging into the concept of beneficial ownership. And the second would be on the indirect transfer. And of course, as we go along with the panel, we will, discuss in greater detail, what the technical nuances of the entire argument on indirect transfer are.
Great. No, thank you so much, Bijal, Ritu. Very interesting that Tiger approached the tax authorities as well as the AR. Rashmi, James, your quick comments and reactions on what happened. What's your take on it?
Thank you, Akash. And thank you, Kaitan, for inviting me onto this august panel. It's an honor and a privilege to join you here, as well as Lightbox, for this conversation. So my quick reaction, actually, and it's also the reaction of my colleagues in Europe and America, is that although this is an AAR ruling, and we expect sometimes to get a negative view from AAR, this is a shocking ruling in many ways. First of all, you have to pay attention to any ruling where the judge says that the taxpayer applicants have failed miserably. That's quite a painful phrase. So that first of all brings you up to attention. I think that the thing that really is interesting from the ruling is that we obviously, when we're structuring internationally, we always have deep awareness of the threats that exist to a very legal interpretation of whether an entity belongs, an SPV belongs in a particular jurisdiction. You can't ever get rid of that challenge. I think one of the things that came out of this case was there was a seeming desire to look at where the head and brains were, and that was enough for the court to really start to walk away from actually the genuine legal residence and indeed the entitlement to the treaty benefits. Of course, once you start looking at where the head and brains are, and I hate to think that you could have the head in one place and the brains in another, we won't go there. But there is obviously a completely open channel then for you to figure out if that entity who has head and brains in another jurisdiction belongs in this jurisdiction at all for treaty purposes. The second shocking thing that I think a lot of tax practitioners in Europe and America will be paying close attention to, and Bijal has already mentioned it, is you can't rely on the Mauritian Treaty and probably the Singapore Treaty to protect, if this ruling's right, to protect against sales of non-Indian companies. That was a very interesting theme to come out of this judgment. And the third thing, again, interesting reading for all of us here outside of India, but there seems also to be a developing theme that if the structure and the entity that sold was not being used to improve or facilitate investment into India, this was just a secondary sale, then somehow that violates the principle of why the treaty should be used. And again, you know, everyone knows in international structuring, you use Mauritius or Singapore and increasingly the UAE to invest into India, but you might also use it to buy existing investments. We acted recently on the Geo platform investment by Mubadala and Facebook, and you know, we didn't really have a thought that you can only really rely on treaties if there's a use of the structure to actually pump capital into to India. So I think, you know, it's always said that what we know already stops us from learning, and I'm always very keen to learn from the Indian courts because the Indian courts seem to have a very imaginative approach. But the natural progression of this judgment is concerning, and it really is that if you think about it from an international perspective, if you don't have a company in Mauritius which has got already existing capital there from other investments, if you don't have reasons to be in Mauritius other than just for the treaty qualification, and you're not putting money into India as a result of that transaction, you're simply buying shares from another company, then I think there is now, even more so than before, a real concern as to whether actually the structure is going to work. And we'll come on to later in this conversation about what we can tell clients about that, and there may not be a better alternative. But I think it is this has really damaged that view that treaty protection is there.
Interesting. Rashmi, what do you feel? What is your perspective?
Sure. Hi, everyone. Good evening. I think, you know, from our perspective, we are a fund and we invest both in India and Singapore, and we have similar investments. I think the single most concerning aspect for us is the fact that if you invest in a non-Indian structure, then the likelihood of that being taxed in spite of it being grandfathered is, after this ruling, is very high. And on the one hand, you had the protocol, and you had some decisions come out of it, and you had a black and white that was printed into Article 13, subsection 4. And with this ruling, that is undone. So I think we go back to the Section 9 interpretations, and we basically look at any indirect transfer as being taxed. In addition to that, I think we have to understand that if the department steps into something just with the intention of proving that it was prima facie done for the purposes of tax avoidance or tax evasion, and they start looking at every structure, every transaction with that lens, it becomes very difficult in genuine cases. Now, funds have, ours is a relatively simple structure, but multiple funds have multiple feeders. They have various jurisdictions, various pools dedicated to certain jurisdictions. Some of them, like in the case of Tiger, have various holding structures, right? The sole purpose of these is not only to evade or avoid tax or just to kind of optimize for tax. There are a lot of considerations. And I think A, the indirect piece, and B, dwelling into such depth of the brain and the head and trying to get into substance over form in very operating matters of a fund, I think is very concerning in it, that sometimes there are some operating decisions or calls which are taken just from a practical standpoint, right? And now, if one has to go into what was written in my financial statements, what was mentioned in every line item of my board minutes, was my signatory a part of the board or was he not? One will just start managing a kind of hygiene or checkbox items rather than getting into really the business of investments and divestments, right? So this is really concerning for us as well. I think as we go through the panel, we'll probably understand a little bit more about what one can do going forward. But my immediate reaction is yes, absolutely, it is concerning.
No, a fair point. Absolutely. Thank you, James. Thank you, Rashmi. Rashmi, the next question, really, in terms of evolution on structures, as with GC and CFO, have you seen, and how have you seen this tax structuring discussions evolve, especially for private equity and venture capital investments? In the last 7-10 years that you've seen, what your really quick take on it?
Sure. So, maybe I could bucket this into three timelines if I could, because, we first invested in the pre-2010 era, though, and we didn't really use a formal fund structure. The treaty was established, FDI was established, it was relatively straightforward. We actually had an investment holding kind of a structure. We invested, and honestly, we didn't face as many issues. We also had, a certain indirect transfers, but at that point in time, I think things were pretty established. I think when we were in the 2012-2013 phase, that is the point in time when the IF structures were also fairly new. And that is the first point in time where we, for us, the key consideration is where is the capital coming from? What is our kind of vision forward on not only investing in India, but are we thinking of some other jurisdictions that we want to invest in? What kind of LP mix do we have? So in addition to tax, I mean, the reality is there are a lot of these considerations which are often not spoken about that go into a fund structuring. At the 2012-13 juncture, the treaty still existed. We had just exited a fund, so we knew that we could rely on the treaty. And frankly, there wasn't much going on around the treaty negotiation. So we went ahead, we set up our pure offshore structure the way it is, because all of our capital was overseas. And what happened was, halfway through the fund, that changed, and the protocol came into the picture. The treaty got renegotiated. At that point of time, we did think of whether we should be moving to a jurisdiction, which supports, say, less or lower tax. Probably we were halfway through our fund life, which made it very complicated, and we were wondering whether we should now shift a balance of it. And frankly, we decided against it. At that point in time, although we knew that post 2017 we will have to subject ourselves to tax for any investments, we decided against, because the fundamental reason for us was to be in Mauritius was A, operating efficiency. We were set, established there. B, like I said, so many factors related to pooling, so on and so forth. So we didn't really unsettle the structure. The third bucket, when really we had to discuss or think about the structure, was in 2018. By then, AIFs were really the way to go. unified structures were great for people who had a mix of LPs. And then there were a lot of LPs willing to come into India, even purely through the AI route, especially the sovereign kinds who had direct treaty benefits. Strangely, again, there we didn't follow the AI route, and I know a lot of funds today are following either an AIF or a unified structure. Again, the treaty was a moot point. We were going to get taxed the same, no matter which route we adopted, right? And we had a track record, and we most of our capital again was coming from overseas, so we continued down that path. Now, with all these changes happening here, and in a couple of years when we are on the next path, I don't know what other considerations will flow in as we decide on the fund structuring. But
Right.
at different points of time, especially in the last around the 2017-18, yes, the degree of structuring did evolve a lot of thought process, not necessarily specific to tax. It was more around, we also wanted to take into factor GAR and substance over form and things like that to make sure that there were no other issues through the investment manager route and stuff like that where we would suffer. So yeah, a couple of considerations over the past 8-10 years that I have seen. But I guess we've kind of stuck to our original position.
Understood. How about you, James? Are there factors involved more or less uniform globally? How are you things from a more broader perspective?
Yeah. Sorry, can you hear me okay? Just wanted to check.
Yes.
I haven't muted myself. Yeah, I mean, I've been doing tax since 1994, and one thing I can definitely say to you is that it's not the issues here are not uniform across the world, and they've been changing radically. There are these aren't new issues that the AAR has been speaking about. I think just the way they were formulated and used to reach the decision might be more shocking. But there's several concepts we need to explode here and keep into different, if you like, different categories, and they are different, although obviously with a ruling like the AAR's on Flipkart, they all come together towards the decision. The first is really this concept of treaty or even just domestic residence qualification. I think yeah, there's a fundamental question as to whether an entity is taxable in a jurisdiction and qualifies if there's a treaty there for that treaty. And every country's got different approaches to that. The US has got their anti-conduit rules written into their treaties. Generally speaking, the UK has said in the past that every double tax treaty has got an implicit anti-avoidance rule, which means that you can't just fictionally locate a company there. The MLI, the multilateral instrument, I'm sure you all know, has made strides in that direction to try and deny the ability of a company to qualify if there's a reason purely for tax to put it in that jurisdiction. But that's all getting at the concept of whether an entity genuinely should be entitled to the benefit of those countries' rules and those treaties, which that country has. The second concept, and it is distinct, but they are sometimes interwoven, is this beneficial ownership concept. Now, just to be clear, there's a difference between beneficial ownership of income and beneficial ownership of assets. Those are two different things. And I studied Roman law at university, and I can tell you it goes back 2,000 years that you can actually separate out the fruit of the tree from the tree. And actually, you have to be careful when you're looking at these cases. Is the court really analysing beneficial ownership of the assets? Which, you know, I heard everything that Rashmi has to say about who owns the actual business and the shares, and who is actually substantively the owner of the business. But equally, you can give away the income, and that's a dangerous thing to forget, because courts can find quite happily that the income is no longer beneficially owned by the owner of the asset. So we need to be careful about beneficial ownership. And by the way, we've had this since Indofoods in the UK, that the UK tax lawyers thought they understood what beneficial ownership was, because the UK tax code only taxes beneficial owners of income and assets. We don't tax legal owners just per se. But then in 2006, I think we had the Indofoods case where all of a sudden UK lawyers had to look at this strange concept of what the French call bénéficiaire effectif, effective beneficiary. And all of a sudden, this OECD case law and guidance came into play. And even today, that fight is still going on, the beneficial ownership debate. There are countries fighting within Europe to decide whether the OECD version of beneficial ownership applies, their local law version, or indeed there's a separate European Union version of beneficial ownership, which I can mention later on. The Italians are getting very upset about the view that there's an EU version of beneficial ownership which is different to the Italian concept. And one tax lawyer, one tax partner said recently at a conference in Milan, this is how Brexit happens, you know, with the view of the Europeans being forced down the throats of local countries. So beneficial ownership is a really tough area to fight on, but it is distinct, as I say, from treaty qualification as a resident. And then finally, and again, these are all different strands, but they are used by the courts as a mix to get to the judgment they want. There's a separate strand of abuse. Now, in the European Union, we have a general doctrine of anti-abuse, and that can be as broad and as wide as you like it. But that has been used very recently in some European Union cases to override whatever the answer might be on treaty qualification, whatever the answer might be on beneficial ownership. If they view you as only using a country to abuse the taxation regime of that country or the treaties, the court will override that. And we've had some CJEU, Court of Justice of the European Union cases, where actually they've cited doctrines of general abuse, abus de droit in French, where they say ultimately, you know, you can't have the benefits, even if we get there on beneficial ownership, even if we get there on the treaty wording, you can't have it because clearly you're abusing the code generally. And that's a very difficult thing to control. So what do I tell clients? I mean, that the bottom line is, if you want insight on this, you have to explain all that to clients and say, you know, this is a risk. Unless you have in a particular country, and in India's case, it will be Singapore or Mauritius, and we'll come on to the UAE because I think that's a really interesting new development, which Mauritius and Singapore can't really offer. Unless you have a genuine reason to be in that country, and I don't mean you like the lawyers there, or it's rule of law, or it's a democracy. I mean, everywhere has got that pretty much that you would be investing through. And it's not about ticking the box on local directors. Anyone can get local directors. It's really about the quality of the decisions there, and more we're seeing directors being selected for their investment expertise. So not just directors who are ex-lawyers or accountants, but directors who have actually invested. We put someone on the board recently who was ex-Goldman Sachs, and that was a brilliant board hire because they know how to do things, and it stacks up. And secondly, you've got to look at recycling capital. I mean, we've now got super holdcos where, and again, this is the theme in the AAR ruling in Flipkart, but if you can have a holdco which recycles capitals from other deals, and not just conduiting new capital through from a fund or from abroad foreign investors, you've got a much stronger case that is Singaporean capital or Mauritian capital that's being used. And it may mean you end up with these super holdcos with long longevities. It's harder for private equity funds, obviously, that need to wind up within 7-10 years. But for longer term investors, infrastructure funds or sovereigns, you know, do think about localizing the capital and recycling it. And I think I'll finish on one disturbing note, and I'm not a psychiatrist, but I think there's some psychiatry required here. I think there's a subconscious thing going on here with the courts and with governments, which is we're all barreling towards, you can predict when this happens, but we're all going towards a market-based system of taxation. That's inevitable. The Indians have got there with space taxation long time, you know, before the rest of the world, taxation of satellite, so for example, and source taxation. But you know, the rest of the world now is waking up that really market taxation is where we're headed. You know, this use of plumbing and strategies in different countries, it's really going to go soon, whether it's through Pillar 2 or treaty interpretation. I would say that the courts are looking at the world as it is evolving, and they are deciding whether they want to allow to give up taxing rights to another jurisdiction, and they are incentivized and they're motivated by this underlying theme that actually where the real markets are, and India is a giant market, you know, there is a need for tax to follow that market and not just on these rather strange reasons to be in Mauritius or Singapore. They won't say that outright, and there is no law. Obviously, Pillar 1 and Pillar 2 aren't yet in force, but I think it's informing how the courts approach it. And I think about a case that in 1990 it feels recent in many ways, but actually it's not. It's from another era called Kofod, K-O-F-O-E-D in Denmark. And you know, there was the court there said, this is 30 years ago, we can't go introducing concepts into cases of treaty law which are vague and indefined because ultimately it breaches the rule of legal certainty. Actually, that's not the case anymore. Courts will now go into places of legal uncertainty. They don't care about that principle. So it's not a great picture for clients. But I can talk a bit more later about how we're getting around those issues. But I would say that we are in a very dangerous new era where I think you can't give a clean view on anything.
Great. No, completely agree. Very insightful. I think quite a perspective on it. Bijal, now what's been your experience in maybe briefly if you can take us through?
So it's been a very interesting, phase of tax structuring in the early 2000s with the landmark ruling of the Supreme Court in Azadi, in the case of Azadi, which really put an end to all litigation with respect to form over substance. All what was required was a tax residency certificate and to ensure that the arrangement was not of a tax evasion. Tax planning, so long as it was within the four corners of law, was absolutely legitimate and still is. We must note this, that this is a specific reference made by the ruling authority. Over the years, with the world really witnessing an intolerance towards tax evasion and conduit arrangements, and the vow of nations to really strike down tax evasion, the investment community was in for a surprise. Well, not a pleasant one though. The regulators, I would say, moved much faster than the taxpayer in the race against tax evasion. This was a time when the taxpayer, I would say, had become slightly, complacent, callous, casual, whatever you call it, in really managing the, Mauritius, Singapore investment structures, which took the structure more towards a tax evasion or a scam, sham, or really a nominee arrangement. And hence the tax authorities really had a gear to deny the treaty benefits. Not to deny that the tax authorities themselves have, of course, attended a lot of international conferences, are a part of the BEPS movement, etc., and of course are very well, equipped to really know the difference between tax avoidance and tax evasion. Evasion. I would say the difference in the source rules of taxing capital gains, wherein the non-residents are charged on capital gains on their Indian citus assets, which is unlike many other countries. For taxpayers, really the unavailability of credit in their home jurisdiction for the capital gains tax paid in India leads really to double taxation, which was again and not really the treaty objective. It's not really a situation, India's perspective of not allowing treaty benefits to flow through vehicles, like say partnerships or trusts, which are commonly used to raise capital internationally, poses another issue and hence leads to double taxation. Further, a lot of focus has really moved in tax structuring to ensure commercial substance and justification investment vehicles, though I would say that the control and management of such structures is still taken on lightly due to the de facto control actually required. And of course, there are, various ways to really, I would say address them. So to conclude, I would say that the war is and has always been against tax fraud and tax evasion, and never against tax planning or tax avoidance, especially for well-planned structures. So it's important that these considerations are clearly looked at.
So maybe I'll try to get bring in Rashmi and ask her that as and you may be discussing with number of LPs, how are LPs looking at this tax uncertainty? Are they accounting for the Indian taxes as a cost of doing business in India, or are they looking for better returns? Look at other kind of companies which may have a higher return. How are LPs looking at it?
So, like I said initially, we went through this exercise thrice. Thus far, I've been through it thrice. When the treaty first changed halfway through our fund, it was going to be purely eating into the returns, right? Because when you went into setting up a fund without, which was not going to get taxed, and there was no question of any grandfathering, it was something that was going to eat into our returns. But fast forward to 2018, we actually set up the fund because it was a neutral position, right? It didn't matter where we invested from, unless we were going to the Netherlands or something like that we were going to pay capital gains tax. So I think the fundamental most important thing is to account for anything as cost, there should be some degree of certainty to it. Now, when you're sure that something is going to be cost, and then you factor the cost in as just cost of doing business, and tax is nothing but that. But when that keeps changing halfway through your fund life, and then when indirect positions are challenged, like they got challenged in the case of the Tiger Global ruling, right? So now what starts happening is your cost eats into your returns. And that's when it starts getting very tricky. So I think the single largest issue is no matter what you try to do, which structure you try to adopt, if there is no certainty, if treaty, you see, either we know that the treaty is going to be honored or it's not going to be honored. Either we know
Right.
that we're going to pay a certain 11, 12% tax, then we know that's the cost. But if we have to keep jumping between not knowing, then it's always going to be a return related discussion. So I think LPs are supportive so long as there's certainty, and then they are able to kind of gauge the outcome of their investments. And when that doesn't happen, the structuring questions keep coming up, and we have to then ensure that our returns speak for what they are. In any case, we always factored in tax assumptions in our returns, but the reality is that it shakes not only the ground of the cost or the return argument, but also whether investing into India then makes sense, because all assumptions keep getting affected.
Good.
So yeah, I would say so far we have the support, but with every such adverse ruling, it means we go back and have a discussion and analyze what's going wrong here.
Yeah, we can imagine. So this topic of grandfathering has come about the discussion, Rashmi, that you picked up, and as well as Bijal, in your conversation, and this whole Mauritian grandfathering for May 2016. Is that in reality, Ritu? Is it possible, perhaps, for a quick academic recap, what's really has changed with respect to existing structure?
Right. So I think the Mauritius route to enter India, as it was, popularly referred to earlier, that was explored enough, exploited enough when the treaty had the provision that Mauritian entity selling shares of an Indian company would not be subject to tax in India. And because Mauritius doesn't have capital gains tax, there was effectively double non-taxation of the income. And there was a lot of, Indian government was trying to renegotiate the treaty, but somehow there was no success. But ultimately in 2016, when the treaty was actually renegotiated, this was plugged, where India actually got a right to tax gains on direct transfer of Indian investments. And the reason could be the whole movement around, renegotiation of tax treaties by G20, OECD's MLI project. That must have pushed Mauritius to come to the renegotiation table and actually revise the treaty. When that happened, the policymakers also ensured that the existing structures, which were set up until April 2017, they are not affected by this change, and those investments were grandfathered. So if the shares were acquired prior to April 17, the treaty exemption continued for them. But for new investments post April 17, there's no treaty exemption for direct investments into Indian companies. If we look at indirect transfer of assets treaty, there's been no change. We had a residuary clause then, we have the same residuary clause now. So whether indirect transfers covered, not covered, that's still a question which this authority has basically a new discussion will open up. And another benefit that was introduced was the transition period benefit, which basically said that to ensure that the effect is not felt immediately, there was a 2-year window from April 17 to April 19, saying investments and disposals made within this 2-year window will be subject to tax only at 50% of the applicable tax rate, subject to purpose test. Again, it's an anti-abuse rule and expenditure test, ensuring that the entities claiming this benefit have some local spend in Mauritius, the prescribed threshold. Only then they will be able to benefit from this transition period exemption, 50% benefit.
Got it. So from a legal perspective, it looks like we're fairly clear that their grandfathering is both under DTA and GAR. But looking at from a more, what I hear from the clients and as a corporate law practitioner, it seems that the tax authorities seem to have adopted a more aggressive, perhaps implicit stance on investment from these jurisdictions. Now, there's been in-depth analysis, and James mentioned about substance and head and brain. But has this dust settled? Bijal, your quick take. Is it we're still in a loop, or is it settled now?
So I would say definitely it's not really, settled. And of course, a straightforward answer to that question would be a no. The legal position as to tree benefits, for pre-April 2017 investments continues to be governed by the Circular 789 and Azadi. The legal position, though it has not really shifted, I would say that the tax authorities have really now looked, at every structure with a microscopic eye. And these would specifically be structures which really come totally before them, like, when they've gone for an advance ruling or a 197 application. Very often, when you have regular tax assessments going on, and, it's, assessments going under the regular tax return route, not necessarily are these really questions. And of course, a lot of the rulings when we see have left certain facts with some open questions, which are peculiar in nature, questioning, say, the legal and beneficial ownership or the head and the brain of the vehicle. Interestingly, the taxpayer himself, in certain situations, actually lifts the corporate veil of the investing vehicle in many cases and acts as if it does not have a head and a brain, and actually takes the control and decision making without really having any, designation as such. These circumstances really lead to a heightened degree of scrutiny by the tax authorities, as they appear as sham, and hence the grandfathered investments, are often called to question. Often the taxpayer is not in the know of of his own facts, and as such as is the taxman, especially due to the exchange of information mechanism which is available under the Singapore and Mauritius treaties. Friends, you'll be surprised to note that the amount of information that the Indian taxman is able to actually garner, through the treaties in itself, is so humongous. And at times, we've seen situations where clients are actually given a document which they do not even really remember having actually been filed. So I guess we must really remember that the tax authorities are dealing with a unique and a muddled position of transition from form over substance to substance over form. So perhaps even from their perspective, it's a little confusing as to, which, policy they really need to undertake. So it's extremely important that the facts and the manner of operation needs to really be clear.
No, great. Thank you. I'm mindful of the time. I'm pretty much on the time, so we'll take another 10 to 15, 10 odd minutes to wrap it up. I think on substance, if James, this is substance-related conversation seems to have gained momentum world over, and it'll be great if you can give us some perspective in terms of what are the factors that are critical to ensure that the tax benefits that investors are, planning or sought to be achieved are not challenged solely on the ground of a lack of substance.
Yeah, and the danger is with substance that it's already becoming yet another tick box exercise. So that there are rules that have got implemented in Netherlands or Jersey or wherever, saying you have to have 2 local directors or you have to have 4 board meetings a year. And the danger obviously is with Flipkart decision, even if you supply all those things, they can still look at what really is going on and decide it's a conduit. But absolutely, I've said to them already, I think you need to have a local director who's not just a lawyer or an accountant, an investment director. You need to have recycled capital if you want to be sure of your treaty substance. You want to have a local office. I mean, not just a local advisor as your office. And ultimately, you want to make sure that the decisions are taken in that jurisdiction. And that's one of the things that in the Flipkart facts was very poor. I wouldn't have allowed the CEO, the founder, to have had signing authority over the accounts. That was a bad optic. And there's genuinely got to be decisions. So we build in a time frame now between the board pack arriving and the board meeting having to take place. Because if you don't, then there's no proof that a decision was taken. So we insist on a minimum of 24 to 48 hours from the LP, the partnership. I mean, it's a very challenging environment to get there, and LPs don't like paying the money towards it, but they have to recognize that, to Rashmi's point, they've got to weigh up the cost of doing that versus the cost of the provision for Indian tax. But there are other things beyond substance we're trying to solve with. I mean, we're telling LPs that you can't get a should opinion on treaty qualification. We're getting them to look at insurance. So if they fail on substance, they can still claim on insurance. We're looking at transparent structures so that even if the substance isn't enough, there's a credit that can be taken for the Indian tax. And we're looking at new jurisdictions. I mentioned the UAE, but I do think that if you're looking at trying to make substance easy, you go where the real people are. And there's a lot of money coming into India from the Middle East. If you can have a UAE business in Dubai or Abu Dhabi with a genuine investment council there, then I think you're a long way along the road. Everyone's in the same boat, so it's not like PE houses are losing out specifically because they are bad at substance and others are not. Yeah, everyone has got this problem. The only thing I would say is that there is you're never going to satisfy a client. You can never tell a client that the substance is enough, and the AAR decision is proof of that.
Understood. And James, you did in one of your earlier conversations you mentioned about beneficial ownership. When it comes to India, I think the concept is nascent. It's developing. We have a very interesting press note about neighboring country investments, which also sort of walks through an element of beneficial ownership. So from your perspective, and you mentioned, how do you look at beneficial ownership? What does sort of go into determination of beneficial ownership?
Yeah, well, as I said, it's a great question, Akash. But there are so many different views on what it actually means. Once you depart from the legal ownership, then really beneficial ownership can be much like in Alice in Wonderland, whatever you want it to be. I mean, I'll tell you the CJEU statement of what beneficial ownership is. That's the Court of Justice of the European Union. They say that the beneficial owner is the person that benefits economically from a payment and has the power to control its disposition. So that's a definition from a court, which some people disagree with. But if you think about what that means, how hard is it to understand? Let's consider Flipkart. Did the Mauritian company benefit economically from the payment to it of any gains or of dividends coming into it, or was actually, because they had to pay it on to a parent, never going to benefit economically? You can take two different views of that question. Did the Mauritian company have the power to control that dividend coming into it, or did it have to pay it on to its parent? Arguably, there are two answers to that question. So where it becomes really important is whether there's a genuine intervening board event to decide whether there was a dividend paid by the Mauritian company. But as I say, once you look at what benefiting economically means and controlling the disposition of reality means, it's very hard to put limits to beneficial ownership. And you've seen other words creep in from courts and advisors trying to explain it more. So beneficial ownership isn't enough now. You need to look at the final beneficial owner, or the ultimate beneficial owner, or the actual beneficial owner, or the real beneficial owner. This is just human beings struggling to give more quality to that concept, because they know within the concept of beneficial ownership, there is no limit actually to what it means. So I'd love to give you a straight answer as to what beneficial ownership means. All I will tell you is that once you are beyond the legal ownership level, it can be anyone really who is benefiting from a payment or an asset or an income flow, and where you draw the line is coming down to the psychology and the politics of tax law right now.
No, very, very interesting, and in a way very frightening for us to plan ourselves. Vijay, from a pure Indian perspective, especially from Indian tax perspective, how do you look at beneficial ownership?
So from an Indian, so it's very interestingly, the concept of beneficial ownership really has not been defined. And I think the most, important, point for us to note is that in any capital gains article under a tax treaty, be it India, Singapore, India, Mauritius, there is no prerequisite of, a beneficial ownership requirement. So the question which really comes up is that, what is this entire thing which, the taxman keeps talking about on beneficial ownership? And, to that extent, totally agreeing with James that, when we are applying the beneficial ownership concept with respect to, articles such as interest income, dividend income, say royalties, etc., the concept of beneficial ownership essentially means that you have a power to disposition over that particular income. In a situation where the capital gains tax article does not really have that concept, the question really arises as to, whether you really need to read that provision in. Now, I would say that, the entire concept of beneficial ownership, when we really look at the manner in which, it has been actually, argued before the courts, it seems like, it has been confused with the entire concept as to who's really controlling and making the decisions, with respect to that entity. So somewhere this entire concept of head and brain, financial control has all somewhere been, mixed into a concept of beneficial ownership, which is perhaps not really the right way to really look at it.
Understood.
I guess it's still to evolve, and it's a question of a little more time before we have some more clarity on it.
Got it. Got it. Now that I have, James and Beazle, both of you, and perhaps Rashmi, if she used, but tax insurance is another, is one of the popular products we've seen quite a bit. Marsh's recent report mentions that the use of tax insurance in India slightly gone down last year, but again used fair bit. Now, given that, Beazle, you've advised a host of insurance providers, does this decision has any impact on how this product is going to be used? Are there insurance premium costs? Are we looking at an increase? How do you see that?
So, well, to put it very simply, insurance providers, one, are well aware of the investigation risk in the Indian tax market at the lower levels. And, for them, the, comforting factor is at the higher courts. It's a pretty much settled position. Now, you'll agree that a risk in itself is core to insurance business, and they would really not be in business if there is no risk. So they are very well within the know of the fact that there is a risk attached to it. And honestly speaking, when we really spoke to them post this particular ruling, trust me, they had, all the arguments as to why this particular ruling, is really, more an aberration than actually what the law really should be. To that extent, while we are advising a lot of the insurance players in the Lloyd's market as a part of the underlying process, we generally would be analyzing all the sets of the facts, the board resolutions, etc. And to that extent, the insurance product has become extremely popular. So far, because these are very peculiar facts and not necessarily all the cases going in for insurance have, similar facts. The insurance premiums have not yet increased. And generally, we've seen an increase in the premium only in situations when, it has been a much more time-tested mechanism and, judicial judgments at a higher level where, the view of the judiciary is somewhere, taking away the benefits, etc.
Understood. James, globally, maybe quick take, how is insurance being in products being taken in M&A deals?
Yeah, I mean, we're loving it in many ways. It's great. It's a way out for many issues, and they're growing. I think the two areas of holdout are transfer pricing and secondary liabilities. Those aren't covered very easily by insurance, but everything else, including treaty, is great. I think the two dark sides of the coin here are cost. Premium will go up, not just because of COVID-19, but also because of the uncertainty issue. And secondly, the pressure that's coming on law firms to write clean opinions, should opinions, goes up as well, because insurers will step in and say, we'll do that, providing the taxpayer has got a should opinion. And we can't give should opinions very often on treaties now. I'm sure Rashmi has to negotiate with lots of law firms who are saying the same thing. We struggle because so much is fact dependent and so much is up in the air. This confusion that Bijan talks about between beneficial ownership and ultimate control. So it's very, it's great in principle to have insurance, but in the details are the cost, which is going up already, and secondly, the opinions that law firms have to write to support the fact that the insurance is given.
Got it.
No, I think I agree with you.
Yes.
Sorry, Akash. I think the cost is a big factor, and I think at least in my experience, as Ritu brought out, let's understand the liability to deduct taxes on the purchaser. And with every treaty being, with every such case that's passed, which is in the negative, the bargaining power of a seller to not be subject to any withholding, really, whether we like it or not, the reality is it's going down day by day, right? So you're struggling with negotiating with indemnities, you're struggling with, and I'm sure they're going to rise the premium for insurance, and you're struggling with the pervasive, values that these negative judgments have. So while one would love to explore it, the reality is insurance firms and insurance courts will come with so many riders. There will be so much detailing into our structure, the way we operate to even come to a court, which would be significantly higher, and the time to close a transaction. And I was telling Bijal this much before the panel. I wonder what is the right answer here. Is the right answer, and I might sound terrible when I say this, to subject yourself to tax and then claim a refund later on, rather than having to deal with penalty interest? I mean, look at Vodafone today, right? If you measure up the penalty interest that have added to the fundamental tax, it's huge. So I think if we have a couple of minutes, maybe that would be really of value to think of what from here on. What's the right answer for us all?
Bijal, what would you advise? I mean, Rashmi's question is pertinent. Do I suffer this process or just pay the tax and refund? I mean, long drawn indemnity clauses and trying to withhold and going to get a 197, initiate a process to begin with. Where do I end? What is the practical way of dealing with it?
So one, I would definitely say that going in for a 197 or an advance ruling is an absolute no-no. I would say that the better option is essentially to go, to file your returns. Trust me, we've seen enough situations where, tax returns have been filed and they have just, they've not been picked up in scrutiny and they've just gone the normal course without really there being any, tax, payment to be really made. I think here it would really be a question of, where really you are in your fund life too. And in situations where, say, you are in the start, etc., right? If you take a position on your first exit itself to actually pay off the taxes, be rest assured that, the remaining period of a fund life, you will never be able to take a contrary position. On the other hand, let's assume you are at the end of the fund life. I would think that yet I would say that, you take a position that it is not taxable so long as your facts are strong on that. And if at all it means, having escrow arrangements with respect to, investors, or you anyways have a provision of investor give back, if those are modes to essentially recover those taxes, in a situation where you need to wind up, that would really be a, better option to go. Going through the refund route, to pay the taxes and then claim a refund, the only point which you are really saving out there is really an interest and a penalty. I would say that, in situations of penalty, in cases where you have relied on a tax advisor's opinion, where, in most cases, the penalty proceedings will be dropped. So it is a question of interest. And, you have a choice whether to really earn the interest with the tax department or to earn it somewhere else. But I guess, once a position is taken of actually paying the taxes, very difficult for you to actually overturn that position with the taxman.
Understood. No, so very interesting. So it looks like that tax indemnity will still be relevant. So one question which is of interest to me as a practitioner and comes about in every deal is about tax indemnity period. So can we have a quick, before we conclude, two poll questions about tax indemnity? If can the audience have a look at the next question? And this is broadly about the optimal tax indemnity period, whether it should be 4, 7, 8. What's the sense? I mean, once filed, if you're filing the return or otherwise. If you can give another 10 seconds for people to vote, and then we will move on to our final poll question and then get a concluding perspective from everyone. Great. So as and when our responses are ready, so very interesting. I think you would see. I was expecting more towards 7, which seems to be the case here, and so this is an interesting take, and we will share what sort of the underlying data, how many number of people participated. Can I get the last poll question here? And this is about the tax indemnity amount. And when you look at X in the following question, it is about X being the amount of tax and an interest for the period that you're looking at. So what is the optimal tax indemnity amount you as a buyer of shares, securities of Indian company would look to cover yourself? Where 2.847 appears to be on the higher side, which includes penalty as well. Great. Again, very interesting result here as well. We see 2.84 to 2x being the highest, which is slightly shift from what we'd seen in the past. I think where some transactions was being done is about 2.84, but very, very interesting. So before we conclude, while all of us have heard you all, industry seem to be slightly rattled by the ruling. Quick take from everyone. Rashmi, to begin with you, what is your message to the industry and the audience who are listening in?
Well, no message really. I mean, I think we're all learned people here, but I think, tax is all about from the point you decide on your structure to the point you exit. It's also about the negotiations that happen, which are deal specific. Now, as Bijal said, right, you're better off not withholding tax, but there could be a seller who's just not, or a buyer who's just not willing to do that, who wants to subject you to tax. So it's a fact-based thing, and I would say that on the operating side, at least, because that's what I can comment on. To the extent what we saw in the Tiger ruling case is that there were some mismatches in the fact pattern, and there were reasons for questioning of substance over form. And I think a lot of us are to be blamed when we start. We set up a structure, we start operating, we get into an operational rut. So I think my 2 cents would be, if you're using a certain structure, please make sure you're actually living, breathing it, whether it's the manner in which you conduct your board meetings, whether it's what you write in your financials, whether it's, declarations that you even provide to a regulator. I think we all need to be very conscious and mindful of that. And, you can't just say that Companies Act is separate from FEMA, is separate from income tax. I think look at it holistically, because there have been instances where even a beneficial owner declaration under the Companies Act has come to haunt people under GAR, or has come to haunt people when the Press Note 3 got released. So I think, my 2 cents would be just to, while it's impossible to look at all the pieces in the puzzle, just try and kind of look at it from end to exit. And then, of course, your own fact pattern and your own needs or reasons to decide on a structure or not are now, after India being, assets being sourced, taxed at source, is not just about tax, it's about many, many other things. And if it's fairly legit and hygienic, I think lesser chances for the taxman to rap us for it.
James, your take, concluding thoughts?
Yeah, we can't avoid the Indian market. It has to happen. And my message to the industry is we'll find ways through this. The first key message is play the realpolitik. I would put yourself in a jurisdiction where you genuinely can, as Rashmi says, live and breathe it. Maybe spend more on local directors. Maybe in a jurisdiction like the UAE, where their complaints would matter a lot more than the Mauritian government's complaints to India, because the UAE is a source of a lot of investment. The second thing is I would work out whether your deal makes sense if there's Indian tax on it. If I'm an LP, I would decide what happens to my IRR if there's Indian tax on this. If the deal doesn't make sense if there's Indian tax, then maybe you don't do the deal. Great to get no tax, but you have to factor in that real possibility. And the third thing I would just say is, interestingly enough, COVID has driven valuations down in lots of IP-rich businesses. If I'm going to do reorganization, I'll be doing it now. If I was doing an exit to try and give me a basis step up for the future, I'd do it now, because you can have a great argument on what the value or the consideration is of the asset. So if there is going to be an Indian tax risk, you might want to take it now while the valuations are lower. And actually, that's an active area of consideration for some of our clients. Okay, you've got the risk, but try and bring the numbers down to give you a better argument for in future.
Understood. Bijal or Ritu, one of you, any thoughts before we sign off from the session?
So I would say mine is more a policy-focused, conclusion, and of course, tax planning within the four corners of the law is yet permissible. If we see any of the negative judgments too, they have always re-emphasized that. I think the lawmakers and the implementators would strike down a structure if it is a case of, tax evasion or sham, and hence it is absolutely important, as Rashmi said, that you really live and breathe the structure which you envisage while you are really in your fund life and in your business operations. That's about it.
Great, thank you so much. And I'm afraid that we are out of time. We have few questions, some we've covered, but what we'll do is we'll try to respond to those by emails. I'm mindful that we're pretty much 20 minutes run past our time. I hope that you found this webinar interesting and worth your investment of your time this afternoon. And like I mentioned, copy of the webinar will be available to you. And if you have any inputs, please do write to us. You can also maybe do a quick survey right away in terms of rating this webinar. What do you think of the webinar, and if there are any ways we can improve it? And while you vote on it, I would say that we are going to be in a world of more scrutiny on substance, like Rashmi, James, Bijal, and Ritu mentioned. One has to be extremely careful on how you create and sort of own that governance structure all through the life of your investment. And definitely, if you are a sort of a buyer of a business, very tough discussions ahead for indirect transfers for sure. Great. So thank you so much, everyone. Thanks, James. Thanks, Rashmi, Ritu, and Bijal, all of you, for taking the time out. And I hope we look forward to be at your service at future webinars. Thank you.